California has some of the most tenant protective laws in the country, and landlord entry rules are no exception. If you own rental property in California, you need to know exactly when and how you can enter, because the penalties for getting it wrong are real. Welcome to TenantScreeningBackgroundCheck.com. Let's break down California's landlord entry laws. California law requires landlords to give at least 24 hours advance notice before entering a rental unit. That notice must be in writing and must state the date, approximate time, and purpose of the entry. Slipping a note under the door or posting it on the front door qualifies, but verbal notice alone typically does not. Entry must take place between 8 a.m. and 5 p.m. on weekdays. California law is specific here. You generally cannot enter on weekends or holidays without the tenant's consent, even with 24 hours notice. California permits landlord entry for making repairs or improvements, conducting inspections, showing the unit to prospective tenants or buyers, allowing a contractor access, performing an initial move-in inspection, and for entry the tenant has agreed to in writing. Emergency entry is permitted without notice for fires, floods, gas leaks, or other situations where immediate action is required to protect the property or tenant safety. Here's where California stands out. If a landlord enters without proper notice, at an unreasonable time, or for an unauthorized purpose, the tenant can sue for actual damages plus up to $2,000 in punitive damages per violation under Civil Code Section 1940(2). California also prohibits landlords from abusing entry rights to harass tenants or pressure them to vacate. That's considered a serious violation under state law. For California landlords, the rules are strict but straightforward. Written 24-hour notice, weekday entry between 8 a.m. and 5 p.m., and a valid purpose. For complete landlord resources and tenant screening tools, visit TenantScreeningBackgroundCheck.com.